Kautilya Namo Namaha. We are discussing offenses, punishments according to Kautilya, as mentioned in his Arhasastra. Last session, we have discussed about the punishments to the judges who mislead, either who indicate some clues to the offenders, or like a defense lawyer, etc., or else giving some clues, etc., or eye winking, anything, any gesture. There are punishments. Kautilya has given the details also. So it means to say that not only the offenders means particularly not labeled. So whoever does injustice to their job, it means to say that offense is atichara. Overcoming the rules is offense. What is aparadha? Who crosses the limits, who crosses the rules, who disobeys their rules, that all this come under offenses. So judges are not spared, and they are not to be excused. Once they commit anything, they are to be treated on par with a common citizen. First, judges are also human beings, then citizens, then employees. Later on, in that particular position, they hold a high position to decide the cases. That's all. It doesn't mean to say that they can act as they like. It is there, of course, even in modern administration also it is there for imposing a wrong, unlawful punishment. Judges also are punished accordingly, according to the offense. So here it is there, and already we have discussed that is a judicial custody, etc. When they are in judicial custody, they are not, whoever are arrested, whoever are in custody. Because unless the offense is proved, that only trial questioning going on, till it is okay. Only just, he is considered as the some accused. That's all. But later on, once it is proved, then only he becomes a offender or criminal according to the case. So when they are in custody, it says, for obstructing a person who is in the custody of a judge or in a prison, that is whether it is in a jail or judicial custody also, the fines are as follows. That means here one should not trouble a person who is in the custody of a judge or in prison. For one troubling himself or one who instigates another to trouble the prisoner is liable for punishment. So this is the rule. This is the rule not only in ancient India, even now also. If at all they are troubled, they are harassed, they are treated brutally, etc. Means all these, if they come to the notice of authorities, they are also considered as punishments, offenses, and punishments will be laid for that. So here, for obstructing what becomes an offense, he is telling, obstructing the sleep, the sitting, the food, the nature calls, the movement, and for binding. These are the. Now, actually, this brutality here, this Kautilya is talking about the persons who committed. Now, if we look at the Andaman jail, etc., the Britishers, how they have done, and how other foreign invaders done, it is not actually not as per the rule or as per the this legal. It is now also this spies, etc., who go to foreign country or who come here or anything. The torture is also mentioned in Kautilya's Arthashastra, but it's not so easily because we have heard about the Andaman history, etc. It was very horrible. Yes, admitted. Yeah. Kashmi was Sundharna. Hello, got it?
आं महोदय नमस्कारः महोदय
Namaskar. Namaskar. Okay. Just now I started. ఇప్పుడే స్టార్ట్ చేశాను.
आम् आं महोदय
మనం punishments for judges, we have been dealing with that. So, for that means obstructing the natural, whatever natural things are there. For that, whether the not offenders, accused, or in judicial custody or in prison, nobody should stop or disturb them from sleep, etc. It is mentioned in Kautilya's Arthashastra. So, if they do like that, then for obstructing the sleep, the fine is 3 panas. The sitting, because now we see how they are tortured in prisons. They are not allowed to take proper sleep or anything. So, for obstructing the sitting position, 6 panas, and see subsequently how that is increased. Obstructing the food means not giving proper food or spoiling it, etc. It is 9 panas. And another thing also so clearly mentioned, obstructing the nature calls. Now we hear so many things because they are not provided with proper, there's a system for nature calls or anything. Nature calls, 12 panas. Because this you should keep in your mind that who are in custody, once the offense is he is tried, offense is proved, then he becomes offender, and that punishments will be there, because for whatever offense is there, according to the offense, punishment will be there. That is a different issue. But when they are in the custody, it's not to absolutely proved that he is an offender or he is a criminal. So he's only like, only just imposed on him. So till that final decision is taken, final judgment is given, he is not considered as common citizen only, but only in the custody. Therefore, harassment should not be made. And the movement, if he is not allowed to move here and there, then 15 panas. And for binding, even when he is in custody, if simply is someone is binding him not to move here and there, binding with ropes or anything, then it is 18 panas. See, actually the minimum fine when we have come across earlier, it was quarter pana or 1/8 pana, etc. That was there. Now it is, at the beginning itself is 3 panas, and gradually it is increased up to 18 panas, means a large sum only those days, according to those days currency or those days money transactions. The same fines should be imposed on one who compels others to commit the above offenses. The judges or jailors or anybody, they may not involve themselves directly. This also it is, we know how it happens. So, but one who instigates others to do all this also, they have to face the same punishment. That means the same fines they have to. And now, this is more important. Nowadays, in movies also, they are showing offenses and punishments to jailers and prisoners. How those who they are the in charges, jailers will be there. So they are also from police department only for harassing the prisoners who are in the prison. Then the prisons, should be cleared every day or once in every 5 days by releasing the prisoners. This is to be noticed, and actually, all this, as I told you, this is to be done in a research manner. This is to be studied with a comparative study now, modern, because actually, we Sanskrit people do not know, but actually, the psychology students, I know our students were there in women's college studying psychology. Psychology students will be sent to mental hospitals to study their psychology, the factors behind their, becoming mentally disturbed. Similarly, like, prisons also, the factors, psychological factors behind the that is committing the crime. So it is a part of study of psychology. Psychology, it is a subject, so they know many, many things. Later only they will settle as counselors or psychiatrists, etc. Because they get lot of information, practical information, not, sitting at home. They visit all mental hospitals and also like prisons, various prisons. So then naturally they will understand the circumstances and they are able to counsel. Now, simply sitting at home, it's not possible. So that here one should find out whether really the prisons are clean or not. They are cleaned like every day, or as Kautilya states, once in 5 days. And by releasing the prisoners means that they should be sent out and the whole thing should be cleaned. And that should be there. Otherwise, we came to know the facts that many people become sick in the jails. And by the time, even if compassionate grounds are, after they are proved non-guilty, by the time they are released, they become, like a skeleton only, because no proper food, no proper treatment, nothing will be there. That is the two things. Here, even this, the same cases with mental hospitals also. Because I know many of our relatives, distant relatives, the people whom I know, when he was put in a mental hospital for the, like, some counseling or anything, that fellow, he was like an elephant, but he has become skeleton after keeping 1 year only, and it is so horrible. Totally, I think his teeth were not cleaned for, I think, some months together. And by the time he brought home, it was horrible. And of course, no sooner he gone to his abode. So this way it is going on in mental hospitals also. In movies, they show hero, heroine, yeah, this is way they treat all this is because it is setting and it is shooting. Setting shootings are different, but actually, if you visit, because when the person was there, my husband personally went to see him taking fruit. So he told that's a horrible situation in the hospital. They are ill-treating him, he said. And later on, of course, he was brought back. And that time it was actually beyond words to explain the situation. So it should not be done. So that way he says the prisons should be cleared every day or once in every 5 days by releasing the prisoners. The prisoners may be released how? By taking work, by inflicting corporal punishment, or by receiving the ransom. Released means actually uh, these three conditions are there. They will be not only just sent temporarily from the room, but also they can be released. How means? By taking work. Some work will be assigned. We see this also in movies, etc. Some canal construction, something, because the physical work they take. And after that, corporal punishment, bodily punishment, whatever is there, that punishment, or by receiving the ransom. This only, like, the offenses which can be I mean, excused by taking this. That means they are not, that's the reason offenders. prisoners, not who commit very that is horrible crimes. For them, it is not there. That means some small offenses, if they are there, then by looking at their work and their sincerity, etc., then some fine ransom means release అవ్వడానికి ఇచ్చేటువంటి విడిపించుకోవడానికి వచ్చేదన్నమాట. కాబట్టి that way, just by paying the ransom, and now also they say so much of fine should be a fine they should pay, and they will be released, like bail or something. It is probably that is like that. So it's not they said bail, but it should be bail word is not there here, but by that way they'll be released. I told you, certain things we have to do comparative study and deeper study also. And the children, the aged, the sick, the helpless should be released on occasions of king's birthday and on full moon days. This is there even now. Independence Day, etc. Some prisoners will be released by looking at that situation only, but their character, etc. So here they say the children, the aged, the sick, and the helpless, Nisahaya, that is, should be released on occasions of king's birthday. That is, almost a national festival. So those days, king's birthday means that is a national festival only. That he and on full moon days, that is, full moon days means Punnama, and that means some each Punnama, if we look at in the calendar, it has got some significance and some festival, beginning with Chaitra Purnima. So full moon days that will be released. According to, again, all these are according to the according to the conditions of the people, and also the nature of the offenses committed by them. So again, same thing cannot be explained in detail by not only by Kautilya, by any writer, because that is to be understood. Here, when once a Rajyangam, a constitution, a penal code is prepared, already that details will be explained in a curriculum, etc. So there every minute things can't be, but one who understands the nature of the offense, that will be implemented. So that way Kautilya is telling in a in a simple manner. So that whatever we should understand how they should be released, and in what way. That means actually that too you can hear what they mentioned, children. So children committing mistakes means when a juvenile, etc. They say. So bala nerastuladi, that also they say under what circumstances they committed those small only, because um, small offenses only. If there are offenses which are to be committed by aged people, if they commit murders, etc., that also will be considered. That is the reason, according to the offense. Always Kautilya mentions according to the offense, they are to be punished, they are to be released, they are to be forgiven, or whatever is there. And aged people also, aged persons also, they are not, in nowadays they are doing, but earlier even aged persons also were simply taken in domestic case, etc. They were put in the jail. Now, of course, relaxations have come. All the prisoners should be released on the occasion of the acquisition of a new territory, incoronation of a prince, or the birth of a king's son. These are the occasions. Acquisition of a new territory. ఏదైనా కొత్తది అంటే ఒక new kingdom is won by them. On that occasion also prisoners, all the prisoners can be released. And incoronation of a prince. Those days Pattabhisheka was different. Nowadays not even 5 years, because Rajyabhisheka, Pattabhisheka, and Janmadina, they were once in a, like, once in a blue moon, they say. But here, even 2 months, the leaders will be changed. Not even 5 years, 1 year, they will be changed. So, on these occasions, these rules are not applicable to the modern society because this is not monarchy, this is democracy. So, here rules definitely different. We have to see from that angle only. All the rules mentioned in Kautilya are not cannot be applied to the modern administration. This is the first fundamental point we have to make a note because the system in ancient India always we should remember one man show and also one man show, but that one man is controlled by the ministry all the minister, Purohita, that also we have studied in the Arthashastra. So there are persons to check the king, check the king's character, etc. He was not all powerful autocrat, autocracy, whatever he wants, like Hitler or something. All these were not there in those days. He was checked by ministers in as far as ancient Indian administration is concerned. If they behave in a wrong way, if we hear or read Mahabharata stories, etc., Nahushopakhyan is there. When Indra was, went to exile, that means, Ajnatavasa, when that after Uttara's that killing or anything, then that position should not be kept vacant, Indra position. Nahusha was appointed as Trilokadhipati, particularly Swargadhipati. But then, when he insulted the Saptarshis, he did all that. That stories you know. Then he was, cursed. That means once a king misbehaves and takes wrong steps, he will be dethroned. That what is done by Kautilya also. Nandas were dethroned by Acharya Kautilya. So this is because that what we say, Arachakatva, all the agitation, people also go on. If you read Mruchakatika also, when the king was totally influenced by his brother-in-law, all atrocities were taking place. Then that there was a revolution. There was a Viplavam revolution by citizens. Then actually one Aryaka, he was a shepherd. He was made king. People have taken, that means he has taken the lead. People have accepted him as king and he defeated that king and he took over the throne. So such historical incidents are there as examples for such things. Therefore, here, new territory incarnation, that is Pattabhisheka or birthday of Rajaputra Utsava, Rajaputra Janmotsava. Then also the prisoners should be released, he says. All the above mentioned are the jubilant occasions. So everyone in the kingdom should be happy and participate in such functions. The jailers should be dutiful. They should neither help the prisoner nor ill-treat them. Jailers should really, it's a very good position. Jailers should have compassion towards prisoners. They need not help directly, but they need not ill-treat them. If they do their duty lawfully, that is more than enough. For the jailer, allowing accused to escape from the custody, the punishment is the middle fine for violence and the payment of the amount of the accused in the suit. For committing the same offense, in case of prison house, confiscation of entire property and death are the punishments. So, if any custody is different, prison is different. He has mentioned prison house and custody. If a jailer, now we are seeing so many cases, whether they are genuine or not, that is a person custody is a hero or a minister's son. All these are again circumstantial things only. When now we see there are actually incidents where influential persons will be given bail or will be released directly, indirectly, all these things take place, and as common people are harassed. All this is going on. That is present situation. We are not bothered about that because that administration only has to look into that. We are not supposed to comment on administration or judges or anything here. But we are seeing the situations, which is right, which is wrong. It is not under our purview. We are only, what we are doing is being Sanskrit people. We are just going through the Sanskrit texts and we are just, because we are dealing with the same legal topics, here and there we will touch the modern topics, but not to comment modern thing. We are almost making a little comparative study, not thorough comparative study, but a little comparative study, because our knowledge is very, very limited. Particularly, we are discussing only with Kautilya. We are not really taking the Mythakshara, which is the source of modern Hindu law, etc. We are not going into detail. I'm here presenting only Kautilyan law. The title also same. Chanakya, I put the title. Only Kautilyan law I am discussing. I am not discussing or comparing a law those days and modern India. I am not doing. It is not my cup of tea because it needs a lot of study. Particularly, one should be well acquainted with the modern constitution and also the penal code. Both should be well acquainted with the sections of law, with the articles of law, whatever are there. Then only we can directly compare. That is the reason only general things I have taken up, not the that for this is under such and such article, under such and such section. That there are hundreds of sections because there are so many sections. General rules are there, exceptions are there, all this is there, and it's not that easy stuff because in the discussion in the courts also, as you know, so many hundreds of examples also they take analogies, sadrushya, because actually this ancient law, it's almost it is also based on Indian logic, that which you have studied Tarka Bhasha, Shodasha Padarthas, Prameya, Pramana, etc., etc. So all that in the Vada, Jalpa, with and all. So all those things should be studied by the person, and that is already there in modern law also. How to argue, and if he is defense lawyer or if he is a government lawyer, how the cases should be tackled. All this is there in the law that we can, at least we can infer, we can understand also. But all that is not going to be explained. Kautilya has given a system of law. That's all. That only we are doing. That is the reason our scope is limited, our knowledge is also limited. This is only for information how that was there in ancient India, particularly with reference to Kautilya's Arthashastra. Okay. So, for the jailer allowing a accused to escape from the custody, the punishment is the middle fine for violence and the payment of the amount of the accused. So, middle fine for violence, so many times it has come 200 to 500 panas, and whatever amount the person, the accused, supposed to pay, that also should be paid by this jailer who makes something arrangements or who allows, who ignores escape, is escaping, etc. And for committing the same offense, this is, custody is okay. He is not imprisoned. But when he is imprisoned from the prison house, from the jail, it is, so much of security is there. That means unless there are the hand of authorities, nobody can easily escape from the jail. So allowing or making an accused to escape from the prison house, from the jail, that is, confiscation of entire property and death are the punishments. So entire property should be seized, confiscated, totally taken away, and also he also should be put to the death punishment. Death punishment is the only solution for that. And now, another important thing for the superintendent of jail, offenses and punishments are as follows. A superintendent of jail, for allowing a prisoner to move, to go out without informing the judge or magistrate. It is issued whenever the person wants to go with the permission only, the accused is allowed to go. Judge or magistrate, because two persons will be there, magistrate powers. If this jailer, that is superintendent of jail, will be there. Superintendent of jail, because each jail has got. So he allows the accuser to move without information, without informing the concerned authority, judge or magistrate, 24 panas for, again, for extracting work from the prisoner without notice of judge. If judges only, they tell them that, yes, you assign this work to him, he can take. Because all we know, so many things, so many works are done by the prisoners, because they'll be assigned to do work, and some supervisors will be there watching over them, their activities. So, for extracting from him, the work from the prisoner, 48 panas. This 48 panas touches the, what we say, Purva Sahasa Dandaha, the first point for violence, because this is really a crime. This is a grievous offense. That is the reason. For sending him to another position or for obstructing the food and drink, 96 panas. I told you this is the maximum amount of Purva Sahasa Danda, sending him to another position, from the prison, sending somewhere, or for obstructing the food and drink for him, 96 panas. For tormenting him, torturing him, or maiming him, then middle fine for violence. For killing him, 1,000 panas. Imagine, lack of death, they we say. So lack of death, the highest Uttama Sahasa Danda, 1,000 panas. Lack of death, why? If it happens, a large amount, those days 1,000 panas means now it runs into lakhs of rupees. Such a fine should be imposed on the superintendent of jails. So many things are given here. And another important point is the thing is, ill-treating the women. This also we have seen. Women who are in the custody, that is the reason they say in the prison or custody, women should be treated well. But how we are seeing, how many atrocities, how many this, incidents take place in the case of women. Not on this is now we have to understand that. See, for every action, reflection is seen in modern society. Bimba Pratibimba. Now, whatever Kautilya mentioned, me actually at times I feel that when I'm reading this text, actually I'm carried away that as if I am reading modern law book only, because modern issues only, because they are so common every time. I am really coming to modern society without what I say, without my, unintentionally, asankalpita only, I am entering into the modern discussion. Actually, modern discussion is not at all there in the book, in my study also, or in my this presentation also. Nowhere modern things, because that time we were advised, because we are supposed to compare with the earlier works, but not the later works. That was the rule when we were doing research in Sanskrit field. I'm talking about 1980s. So that time we were told. Actually, I too was eager to make a comparative study with the modern thing, because I wanted to compare with. I really borrowed that IPC book also, Indian Penal Code book also, from my lawyer friends. I wanted to do some, that we say, some observations. But immediately I was told that no, you have to compare only with either Ramayana, Mahabharata, earlier works, but you are not supposed to do modern works. That is the reason even in my administration work also, I have taken only three. That is, Manusmriti, Kautilya's Arthashastra and Yajnavalkya Smriti. Because Yajnavalkya Smriti, because it is considered as the source of modern Hindu life, it is taken and it is considered as an authoritative work. And Manusmriti, actually, Manusmriti, whatever is available now, is not older than Arthashastra. But Manu's views are mentioned, quoted by Acharya Kautilya. That is the reason at least present Manusmriti I have taken for. I am allowed to take for my study in that time. Even offenses, punishments also. Here and there I have taken the views of Manu and Yajnavalkya, here and there, not thoroughly, not completely. So because Yajnavalkya, of course, Vyavaharadhyaya completely discusses about law. If at all anybody compares, then Kautilyan law and Yajnavalkya law can be done very well because Yajnavalkya Smriti Vyavaharachaya is the source, particularly the commentary Mitakshara on that is the source for modern Hindu law. So that way, actually, Hindu law, it is really introduced in the curricula. It is a prescribed text for the law students. Only that much only. I think one paper or something, whatever is there. So that way, if anybody wants to do some comparative study, they can do Kautilyan law and Yajnavalkya's law, that is Mitakshara. So they can take Kautilya, they can take Mitakshara, then they can jump into modern law also here and there. So this can be done, but persons should be well acquainted with law. Unless they are well acquainted with law, only just taking these Mitachara and Kautilya, they can't do justice, I believe. So that way, I was not allowed. That is the reason but otherwise, such a beautiful description is there by Kautilya. Anybody who ever comes across this treatise, they feel like comparing to the modern Hindu law. Not only that, but whenever I talk about Kautilyan law, the people in the assembly definitely they pose questions. There is scope, they pose questions. What is the comparison between those days, that ancient law and modern law? This is also, there is a scope for that. But for that, the thorough research, thorough study should be made. As I have not done that study, that is the reason I am not giving a comparative statements in my these videos. I wanted to at least bring the information to the audience regarding ancient law so that anybody, whoever is well acquainted with modern law, they can at least do some research or they can write some articles on these particular, some different issues. It may be useful because Mitakshara is okay there, already there. But a Kautilyan law means only again this is used in debates. In constitution, Kautilyan law nowhere introduced. Mitachara introduced, but not this is introduced. That is the reason we cannot even take this as authentic to incorporate in that. And further research should be done when some amendments take place. If they feel that there is some possibility or feasibility of incorporating any things from Kautilya or ancient thing, then it can be done. It needs like debates, and that is the reason actually now Indian knowledge system, the subject which is very a recent one, people or Indian administration is focusing on IKS. And this and part of IKS, they have introduced Arthashastra also. Along with all other Shastras, Arthashastra is also introduced in the curriculum. So tomorrow, in future, there may be a possibility of taking certain points of administration, law, and other things into modern, what we say, modern constitution or anything. That, of course, I do not know about the future. But this is what, at least these my videos may be useful as a reference. That is the reason my effort. That's all. That much only. Otherwise, only by reading Kautilyan law, what will be the use means there is no answer to it. This is the purpose of my presenting these views. Now, okay, for the jailer for violating women prisoner, the punishments are as follows. For violating married woman prisoner who is a slave or pledge of others, the punishment is lowest fine for violence. Here, this indicates that ఆ రోజుల్లో bonded labor అని మనం అంటాం కదా, the bonded labor was there. Actually, that is also a big chapter in Kautilya Shastra. We can't blame Kautilya or anyone because till recent times also, Jamindari system or Dora system, Gadi system, it was there. I know the people, it is almost like, mortgage or pledged, whatever you say, they used to give some amount to the parents, For example, very poor people, those days, like 1,000 or something, and towards interest. They don't pay salary to the boy. They child labor was there. They used to pledge their boy. This I think many people who reside in cities, they don't know. But those who stayed in samsthanas, etc., like me, they understand it. So that is a vetti chakri, etc. Also they say. So the boy will go on doing that. At least bank interest, penal interest will be there. Interest on interest, that is, simple interest and compound interest. In Sanskrit and Telugu terms, it is baru vaddi. We have studied in Telugu medium. Baru vaddi is simple interest. Chakra vaddi is, compound interest. Interest on interest is called Chakravadi. That is, rotation. Banks pay like that only. Every quarterly, they say quarterly, they impose the, even what we say, that interest on, if we take loan, the compound interest will be imposed on us. And if we deposit also, the same compound interest will be paid to our deposits also. So like that it was there. So this is a pledged women. They used to pledge women even now. I know even modern times also, many people send their people now in videos also it is coming. No, they send their daughters as maids to Dubai countries somewhere. So that is nothing but they take some amount from those owners and they send their children, their ladies, etc. That is going on. So, if such person is in prison, if she is violated by the jailer, then the punishment is lowest fine, that is 48 to 96. And already married. She is married but already pledged. For violating the wife of a thief or of a rioter, the punishment is the middle fine for violence. So, violating wife of a thief, she is not a pledged woman. That is the reason the fine is middle fine for violence. That is, 200 to 500 panas. Now, for violating an Arya, a noble woman, the punishment is the highest fine for violence. Because by chance or by she might have committed also, but she hails from a noble family, very good character. I mean, her records are very clean. So for violating such woman, the punishment is highest fine, means almost up to 1,000 panas. And then for committing the same offense, the prisoner should be executed on the spot. This is for jailer violating. But if a prisoner, these things also we are seeing in the prisons, the gundas will be there. If a prisoner violates the people, that is, women in the prison, then he will be should be executed on the spot. The death punishment is there, then there itself. And for arresting an Arya woman at the forbidden hours, the punishments is the highest fine for violence, and for arresting a woman who is a slave, the punishment is the lowest fine for violence. Here, forbidden nights, forbidden hours means మనకి ఇప్పుడు కూడా అదే now also they tell night times now how they are doing it is illegal. During night times women are not supposed to be arrested. One should not arrest a woman during night time. They are called forbidden hours, prohibited hours. రాత్రుళ్ళు ఆడవాళ్ళని అరెస్ట్ చేయకూడదు, పోలీస్ స్టేషన్ లో ఉంచకూడదు, ఇదంతా కూడా చెప్పబడింది. అందువల్ల అర్ధరాత్రి అరెస్టింగ్ ఉమెన్ ఆఫ్ నోబుల్ ఫ్యామిలీ, the highest fine will be there. And for a lowest family, for a simple lady means who labor work, etc., then it is lowest fine for violence. So these are to be taken into the notice, and one should be very careful while implementing all the things. So these are the really what we say things are there. So just a minute.
ఓకే మేడం.
Okay, ఒక నిమిషం.